Thank you for tuning in our YouTube channel, The African Dignity. Let us continue with our lessons in the law of evidence. I understand that Dr. Naidu has done work to as far as lesson 6 or topic number 6. So we will start now at topic number 7. I think by the time she comes back from her sabbatical, we would have done quite a lot. So I hope that everyone will be useful, engaging, because with this course you need to be engaging so that I will understand where you are lost, what you don't understand, so that I can help you, that nobody is left behind. But let me stress that I know some of you have heard of a case called, or something called, Plascon events rule. What do I mean by the Plascon events rule? Right? Every law student should know this, because I'll tell you, when you are being interviewed for your articles, this question will be asked. When you are interviewed to be a magistrate, you will have to answer something around the Plascon events rule, right? It's an old rule that has been adopted up to now. In order for you to understand this concept, you also have to read a case of Stellenbosch Farmers Winery Group Ltd, and another versus Martel and Sier and others. It's also the same thing. And also read the Plascon events case. I think it's versus the Kruger Paints. Oh yeah, I'm not sure, but it's called the Plascon events case. You must read the rule in that, and the rule simply says, when a factual dispute arise, right? When the factual disputes arise and a relief is sought, the court has to do this. The relief should be, the court must grant the relief, right, only if the facts stated by the respondent, right, together with the admitted facts in the applicant's affidavit, justify the order. You must remember, the issue about the Plascon events rule arises when you are at motions court, and you'll find that you are making an application using affidavit. There is no oral evidence to be led. Each and every ruling depends on the papers that we have both submitted, you as the applicant and the other side as the respondent. Now, what it says is that as the presiding officer has to look at both submissions in papers, that is now the applicant's papers and the respondent papers, and make a ruling based on that. Look at it if it says it makes any sense to you, and then you will be able to make a ruling. Sometimes you might say, okay, I think in order for us, for me as a presiding officer, to comprehend what is in this paper, I would rather seek clarity by calling for oral evidence. But normally, the courts are obliged to make a ruling based on the papers before the court. Especially where you will see sometimes, another example is where there is a dispute about somebody who has failed to pay, installments to a car, and the defense that is raised is that the applicant, right, who is applying for default judgment, if you like, or applying for an order to repossess the car, that the respondent is saying no, it should not be granted because the applicant did what is called irresponsible lending. Irresponsible lending is where you know that the person is not working, and he tells you upfront that I am not working, but I want you to borrow me 300,000 rand so that I can go and buy a car from a particular garage that's selling cars. I want to go to Ford or to Toyota to buy a vehicle, but I am not working. And he gives you an explanation is to say, I am going to use this vehicle to convey stuff to Fosco or to Mondi, and the money that I'll get there is estimated at 6,000 rand a month. Then I'll be able to pay 4,000 rand a month towards installment, and you think that is enough. But in terms of the National Credit Act, you cannot borrow that person money because he tells you upfront that he's not working. So if you do borrow that person money, that will be regarded as irresponsible